police officers tried to manufacture a reason to prolong the stop. They detained Mr. Davis legally, but then they asked him whether he had anything to drink even though he wasn't driving. They asked him whether he had any dope on him. Then they commanded him to close his eyes for a minute. And finally, they accused Mr. Davis of being too talkative when he finally couldn't take it anymore, and told the officers that he will invoke his Fifth Amendment right to remain silent and that he wanted a lawyer. In turn, the police officers arrested him for impeding an investigation. Now, we know that under Rodriguez versus the United States, the Supreme Court told us that officers cannot prolong a stop by manufacturing reasons or by asking unrelated questions to the traffic infraction. So today, we're going to look whether Mr. Davis's Fourth Amendment rights were violated. And before we go on, I want to thank you for watching me here on YouTube. If you're new, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, I want to thank David for purchasing a number of promo kits from my website, which include the Do Not Arrest This Person t-shirts. If you want to be one of those people who supports my channel, go to loststash.com and check out some of the merch, which includes the Do Not Arrest This Person t-shirts, hats, and other items. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we'll be discussing United States versus Robert Davis, which is a case from the Northern District of California, United States District Court. So we're still at the trial level. We're not going to the appeal. And this is where the trial judge is doing the right thing. We're talking about the suppression issue. I already gave you some of the factual background, but let me fill in some of the gaps. Officers received a call from the owner of an Airbnb who said that they rented their house to 4 individuals, but they see that there's a huge party, there was a lot of noise, lots of traffic, and they wanted the police to come out and take care of things. Officers get to the scene, they see a bunch of people, a bunch of cars parked, and they notice that a silver Nissan Maxima is parked nearby. They also realize that they have an impound warrant for this vehicle because it was used in commission of a felony. So the officers wait a few minutes, then they see Mr. Davis and his brother approach the vehicle. Now the brother was the one that had the keys and he was reaching towards the driver door, while Mr. Davis was approaching the passenger side. The officers intercepted the men, explained to them why they were there, and told Mr. Davis and the brother that they're being detained and wanted to be questioned about the vehicle. At this point, the officers began to handcuff Davis's brother. They also decided to pat down Mr. Davis and handcuff him as well. Both of the men were protesting and saying why are they being detained or whether they're being arrested. During the whole interaction, both men were being pat down. When Mr. Davis was being pat down for weapons, for officer safety, nothing was found except the officer did say, "What is this in your front pocket?" Mr. Davis said that it was his wallet and not a firearm. Then, during the pat down of Davis's brother, the officers found a firearm. So they went back to Mr. Davis and patted him down one more time, just in case. Again, nothing was found. Then the officers began to question Mr. Davis. They asked him whether he had any dope on him, and he said no. Then the officer asked Mr. Davis to close his eyes. He did for a minute. Then he opened them up. The officer was trying to look into his eyes, but Mr. Davis kept saying, "I don't smoke any pot." Then the officer asked Mr. Davis whether he had anything to drink or whether he took any medication. And finally, the officer then said, "You're being too talkative." because Mr. Davis kept asking whether he's being arrested or detained. When Mr. Davis could no longer take it, he said that he was using his Fifth Amendment right to remain silent, he's invoking it, and he wants a lawyer. In turn, the officer then told Mr. Davis that he's being arrested for impeding an investigation. Now that the arrest ensued, the officer then proceeded with search incident to arrest. During the search, they found a loaded Glock on Mr. Davis. It had 12 bullets in the magazine and 1 in the chamber. They also found a small amount of cocaine and some other incriminating items. Now, Mr. Davis argues to the district court that all of these items should be suppressed and cannot be used against him in court because the officers violated his Fourth Amendment rights by prolonging the stop and manufacturing reasons to prolong that stop. Before we go on, let's look at the Fourth Amendment and carefully read United States versus Rodriguez decision. The Fourth Amendment guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. When determining whether someone's Fourth Amendment rights have been violated, the ultimate touchstone is reasonableness. Even an initial seizure based on probable cause can violate the Fourth Amendment if its matter of execution unreasonably infringes interests protected by the Constitution. A police stop exceeding the time needed to handle the matter for which the stop was made violates the Constitution's shield against unreasonable seizures. This is, of course, Rodriguez versus United States, the 2015 Supreme Court case. So again, a police stop exceeding the time needed to handle the matter for which the stop was made violates the Constitution's shield against unreasonable seizures. Specifically, whether a seizure for a traffic violation justifies a police officer's investigation of that violation and the duration of an officer's inquiries is determined by the seizure's mission to address the traffic violation that warranted the stop and attend to related safety concerns. Davis does not contest the legality of the initial stop and the pat-down, and rightfully so, says the court. In light of the impoundment warrant for the Nissan, the officers were able to detain Mr. Davis and pat him down. That's not the question. The question is whether the officers were allowed to ask all of those questions that followed and prolong the stop. Again, let's summarize Rodriguez. When the officers stop an individual, they should reasonably attend to the mission of the stop. For example, if they stop you for speeding, the officers should initiate the citation, start writing it down, and once it's done, they shouldn't be asking you about the weather or anything else. They should give you the ticket and let you move on. So, in this situation, the officers stopped Mr. Davis because there's this warrant to impound the vehicle, but then they proceeded to ask a bunch of questions. Was this legal under Rodriguez? Here's what the court says. The government's attempt to characterize the situation as an evolving one misses the mark. To the extent the situation did evolve, it was due to Sergeant Currie's unlawfully prolonging what should have been a brief detention so that deputies could impound the vehicle. Otherwise, law enforcement would be free to extend any detention long enough for probable cause to materialize for some offense, even if wholly unrelated to the offense justifying the initial intrusion. This incident illustrates the danger of permitting law enforcement in manufacturing reasons to prolong the stop. So in this case, the officers should have detained Mr. Davis and his brother briefly, begin impounding the vehicle, because after all, they had a warrant to impound that vehicle, and let the two brothers go. That should have been the end of it. And asking Mr. Davis whether he smoked any pot, whether he had any of it on him, why his eyes were glassy, whether he had anything to drink even though he wasn't even driving, and whether he had anything on him, period. All of those questions illegally prolonged the stop and violated the Fourth Amendment and Rodriguez versus United States, which means that all of the fruits that were found on Mr. Davis, the Glock, cocaine, and the other incriminating evidence, should be suppressed as fruits of the poisonous tree under the exclusionary rule. So the suppression motion is granted in this case, and once again, all of those items cannot be used against Mr. Davis in court. I hope you've learned a little bit more about the Fourth Amendment and specifically Rodriguez. Of course, Rodriguez versus United States is a big Supreme Court case, which I've discussed in detail on this channel here on YouTube. I've also discussed a number of other variations. We've talked about Rodriguez last week. A few months ago, we talked about an example out of Kansas where the officers would do sort of a double take where they would give the motorist the citation, let the individual sort of go, they would tell the person they're free to go, and then they would come back to the car and go, wait a second, one more question. Well, the court in Kansas held that this was also illegal under Rodriguez versus United States. It doesn't matter how the officers extend the stop, whether they do it before issuing the citation or after. If they prolong the stop, that's illegal under Rodriguez versus United States. And of course, we now have this other example out of the Northern District of California. I hope you enjoyed this video. Give it a thumbs up. If you're new to the Law Stash YouTube channel, please subscribe. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and other items. Those other items are stickers. I have Do Not Arrest This Person sticker, one that comes in flat, one that comes as glow in the dark. I also have a sticker that says I don't consent to searches, which you can put on your vehicle or in your gun case or wherever else. If you end up buying one of my products, I ask you to take a picture, you wearing that Do Not Arrest This Person t-shirt in the wild, tag me on Instagram or Facebook. I really enjoy seeing you wearing my product, and it gives me joy to see it in the wild. Thanks for watching. I'll see you next Wednesday for another deep dive on another criminal case. Thanks for watching.